and the defense. All right, there isn't any need for an argument. And you have evidence of that fact because you have Exhibit A, is your letter of acceptance, Exhibit B, your notice of default and opportunity to cure, and Exhibit C, which is going to be your default notice from your notary. All right, those three items are always needed in any type of situation that you're seeking to resolve an argument or an issue or a controversy that you have with someone in the public. For a matter to be resolved, it must be expressed. This is what on your 10 commercial maxims of law. That's one, I think it's number 7, okay? For a matter to be resolved, it must be expressed. So you have to put it into writing, all right? You also need 2 witnesses, all right? So the 3811 form, which is your green card of your certified mail that you're sending in the mail, your correspondence, that is a witness. The post office is a witness. And also the notary is a witness because the notary is the one that's going to conduct the process for you. The notary is the one that mails the papers. That's why you make sure your notary has a P.O. box. And the notary is the one that comes and checks the P.O. box to make sure that they mailed something back or attest to the fact that nothing came back. The notary is your witness, all right, to the transaction. And look, this man right here attempted to resolve this issue with these people before we got to court. See, I think that's a lot of times what people think. They get a criminal charge and they think you have to go to court to resolve it. You don't have to go to court to resolve it. What do you think that the attorney does to you when he gives you a plea deal? A plea deal is you resolving an issue before you get to court. He's offering you terms. You're going to accept them or not. And if you won't accept them, he say, okay, let's go to trial. Well, you're doing the same thing. You're offering them terms. And you say, well, look, I'm not going to argue any facts. I'm going to agree with all your facts. Okay, and I want you to settle and close this matter. So there's no need for us to go to a trial. The danger is always trying to take you to trial. They're always trying to take you to trial. They're always trying to hold that over your head. They'll try to railroad you into trial. The thing is that you need to have something on the record showing that you are not disputing any of the facts in the case. You've heard me say a lot of times, I'm the holder in due course here as a third-party intervener making a special appearance as an authorized representative for the defendant. I accept for value and return for value all the charging instruments in this matter and make my exemption as principal available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts contained in the charging instrument. Please use my exemption for offset and adjustment of the public charges against the defendant and release the order of the court to me immediately. I want settlement and closure of this. God, I don't want to argue anything. You know what you're saying. Look at their face while you're saying this. Look at them in their face while you're saying it. And watch how they start. All this right here. Watch the body language. Watch the body language when you ask your attorney, can I get the bid bump? See, the first thing you have to do is you have to convince yourself what I'm telling you is real. I can't do it. You got to do it yourself. You got to represent yourself. A sovereign, you're not a real sovereign until you've been in the court anyway. Until you've actively attempted to try to defend your rights yourself. That's when you're sovereign. A sovereign is responsible for himself. A sovereign is not going to allow somebody else to be responsible for him. You know, getting a public defender is a good thing. He's a good thing because he's there in the public. He defends the public is what he does. He's a public defender. He's not a private defender. He don't defend private rights. He's a public defender. All right, all of them work for the state. All of them work for the state. The public defender works for the state, the prosecutor works for the state, and the judge works for the state. It is the biggest joke. This is just the biggest joke that I can think of when them people be giving us attorneys and shit and trying to act like the attorney has our best interests at heart when all 3 of these motherfuckers work for the state. How the hell are you gonna win and all of them work for the state? All right, so your mindset, it's gonna require you to have a different mindset. You gotta let the state win. You're looking for a win-win situation, not a win-lose situation. You cannot approach these courts with a win-lose situation when you're going against the state. They're gonna win 98% of the time. If you approach them with a win-lose mentality, you have to approach them with a win-win mentality. I want y'all to win and I'm going to win. What they are seeking is they're seeking some kind of money because they're $30 trillion in debt. The statutes are cross-referenced and cross-indexed with bonds of a certain amount. This is how they're making money. This is how they're financing government through charges. A charge is a lien. Let's look at charge real quick. Let's look at it. Hopefully y'all are on the internet watching all of this. Okay. So we're going to look at a charge real quick. Let's go to the classroom. Get on here and go to the classroom.
Is the order of the court, is that a second?
The order, yeah, it's from the judge. Finally give me the order. You know what I'm saying? The ruling.
Oh, the court order. Okay,
right.
Court order.
All right, so we get on here and we get into our legal dictionaries. And right here, you watching the screen, man? You see what I'm doing?
Yeah, I'm on there.
All right, okay, good. So I'm gonna go to Black's Law Dictionary. We're gonna look up this word charge real quick, because I gotta change y'all mind about some things, all right? So we're gonna look at this word charge real quick, because that's another thing that gets a lot of people. They think they know what these words mean. They say, man, I got me a charge. You don't even know what charge means. You don't even know what a charge is. You sitting there walking around talking about I got a charge, and you don't even know what the word means. What is a charge? All right, let's look at charge. Let's look at what a charge is. That's the first thing. We need to know what a charge is. All right, so here we got is a charge. Now we got 7 different senses of the word charge. Number 1, a formal accusation of an offense as a preliminary step to prosecution, a murder charge, also termed criminal charge. All right. Number 2, an instruction or command, a mother's charge to her son. Number 3, a jury charge. Review the charge for appealable error. Number 4, an assigned duty or task, a responsibility, the manager charged to open and close the office. And here it is, number 5, an encumbrance, a lien or claim, a charge on property. How do we know when we go into the courtroom which one of these charges they're talking about? Okay, when they say, well, you've been charged with X, Y, and Z. Now, the first thing you do when you go into court and they want you to plead, you ask the judge, you say, Judge, I'll be more than happy to enter a plea into the record. However, I have seen no charges. What they will do is they will bring over an indictment or an information or an accusation and put it on the desk in front of you. You will calmly pick it up, look at both sides, and say, Your Honor, I see no charges. I request that the Honorable Judge direct the prosecutor to read the charges into the record. The first thing you have to do is require them to read the charges into the record so we can establish liability for the individual who is bringing charges against you. Remember, if somebody in the public is bringing charges against you that are unfounded and unwarranted, then they are liable for that. Somebody has to pay for that, especially if it involves you losing your liberty. This is why it's very difficult to beat these people, because they don't want to accept any liability for anything. And these liability can reach into the millions of dollars very easily, because there's a charge for every minute that you hold somebody against their will in jail and they didn't do anything. So they don't get you to plead to something. They have to. Whether it's a misdemeanor, they reduce it or something. They want you to plead to something because they don't want that liability. It's a lot of fucking money. It's millions of dollars for holding somebody in jail and they're innocent. 200 million, 300 million, those are the type of numbers we're talking about. Those type of numbers we're talking about, all right? So this is what is at stake for them. They got to make sure that they find you guilty, okay? This is why they're so reluctant to drop charges, because there's a lot of money at stake. A charge is a lien. The only thing they can put a lien against is your social security number. That's the only thing that the government has to put a lien against. That's the only connection that they have to you as a private citizen. This is why you do a secure party process. You're putting a lien against your social security number, so you already have one in place. Anyone who does mortgages, you understand what I'm talking about. That's why you do a title search, to make sure if you're going to do give a loan against a home, you can't have somebody else in the first position, because if there's a foreclosure, you get second. The first person get all the money, he's going to get every dime of his, and you're going to get what's left. So that's what you're doing. You're putting a $200 million, $300 million, $200 billion lien against your property, and then they can come with their lien if they want to, but it's second in line, and you will pay them out of the credits that are on your bond on deposit with the Treasury Department. You coming in as a third-party intervener, that's Rule 24 of the Federal Rules of Civil Procedure. You're intervening on the matter because you have property that is apparent that is in danger. Your property is your straw man. Your property is your estate. If you want to see examples of this, let me show you an example here in Georgia. And they got it in all the states. It's not in this